Hello, thank you for joining me today for Real Estate, Religion, and You. My name is Dr. Sylvia Black, licensed real estate broker with affordable homes and apartments, and I'm licensed to preach and ordained as a minister, and I have a master's degree in sacred theological divinity. And I want to thank you for joining me today for Real Estate, Religion, and You, which airs every Wednesday right here on Time on the Public Access TV Channel 20, Wednesdays 6:30 to 7. And Saturdays from 12:30 to 1. And then thank you for joining me today. Today I'd like to talk to you on a continued basis of my book, You're Fired. This book is available on lulu.com. And it talks about how to, should have got the other book. Actually, it's Handling the Exit Interview with Grace. I got the old book. Handling the Exit Interview with Grace. And today we're going to pick up with what you need to know about filing a wrongful termination case. For the last couple of weeks we've been talking about if you feel that you've been wrongfully terminated from your job, regardless of the length of employment or the type of work that you were doing or the capacity in which you were employed, you still may have a lawsuit on your hands. The best thing to do, if you're not sure, if you feel, you contact these agencies by writing them a letter and explaining exactly to them what happened during your tenure, and then they will let you know whether there's a lawsuit available to you. There's several organizations that we talked about last week, and there's almost an organization that covers every kind of discrimination. Okay? Now, what you need to know about filing a wrongful termination case. Losing your job can be a traumatic event, I should know. Okay? From one day to the next, your whole life takes a change. The sudden loss of income is devastating, especially in the face of monthly bills and other financial obligations that you have. You may feel shocked, embarrassed, angry, helpless. Fortunately, most states have wrongful termination laws to protect employees like you and me. While the issue of wrongful termination, also called wrongful discharge or wrongful dismissal, varies from state to state, there are some basics governing the rights of employees. And understanding how your state deals with wrongful termination cases is vital, especially if you're considered an action for wrongful discharge against your former employer. Okay? They may have prevented you from getting unemployment. Okay? You can write to the organization and find out, did they lie? They lied about, what you said. Maybe you could sue for that. Okay, now, what is at-will employment? Virtually all 50 states follows the at-will doctrine of employment. The at-will doctrine states that an employer can terminate you from your job at any time, for any reason, without fear of legal consequences. There are 5 basic exceptions to the at-will termination. Okay? Exceptions to the at-will doctrine. Number 1, public policy. Terminating your employment because you filed a workers' compensation claim or because you refused to break a law, lie under oath, or refuse to conspire to discriminate against a job applicant based on race, color, creed, age, or gender are all grounds for wrongful termination suit. Sometimes sexual preference is also a basis. The public policy exception extends to whistleblowers, for only when the whistleblowing concerns health and safety, state or federal law violations, illegal company activity, or unethical business practices concerning price gouging, antitrust violations, and similar heinous employer behavior. 43 states have adopted the public policy exception. Those states that have not are Alabama, Florida, Georgia, Maine, Nebraska, New York, and Rhode Island. Okay? Next is implied contract. Terminating your employment when there's an implied contract between you and your employer is also grounds for wrongful termination lawsuit. An implied contract of employment is an unwritten one. You may have an implied contract with your employee if he or she made an express representation verbally about your job security, such as if you leave your former job and come to work with us, you'll have a job forever. Or you're doing a great job for us. If you move from your state to our corporate headquarters, we'll make you a new district manager. A more common type of implied contract lies in the employee handbook. It's always copied. Whenever they give you the policies and procedures and all of that about the company policies, take those home. Okay, because you're going to need them later. When employers tell employees their rights and duties of employment are at the company's written handbook, also called employee guidelines, regulations, policies and procedures, standard of conduct, the employer has an implied legal duty not to terminate employment as long as the employee complies with the duties of employment as set out in the handbook. In these cases, the employee handbook serves an implied contract of employment. Now, you may contact a lawyer. Let's say you may have contacted a lawyer. You may have said, okay, let me contact a lawyer and see if they can handle the case. Don't get discouraged if one law firm decides that they don't want to handle your case. Because a lot of law firms, you have to remember, they're into the big bucks. I called one lawyer and I told her, the first thing I said was that the company violated their own policy. And immediately she started defending the company. And I'm like, is this the person that I'm going to want working on my side? I don't think so. And she started talking about, oh, well, the company's not wrong if they violate their own policy. Not necessarily. She's like, okay, what happened? No, thank you. Click, you know. So don't get discouraged if a law firm tells you that they cannot represent you, okay? They cannot help you. That's why I said right to these organizations, the federal, state, and government agencies, these organizations, to find out if they can help you. Because if they can help you, then you know you got a lawsuit, okay? You need to write to them all, okay? And that's what I'm about to write to the rest of them too. Okay, the employer has implied legal duty not to terminate employment as long as the employee complies with the duties of employment as set forth in the handbook. In these cases, the employee handbook serves as an implied contract of employment. Now, that's what happens in a lot of cases, isn't it? When you go to, I know that happened to me. When the employer says, as long as you follow the rules and regulations that's stated out in the handbook, you don't have to worry about being terminated. Has the employer ever said that to you? If they did, then you have a ground for lawsuit. Implied contract representations are subject to interpretation by the courts. To decide if an implied contract of employment exists, the courts study the underlying circumstances of each case. 37 states have adopted the implied contract exception. Those states that haven't are Delaware, Florida, Georgia, Indiana, Louisiana, Massachusetts, Missouri, Montana, North Carolina, Pennsylvania, Rhode Island, Texas, and Virginia. So New York, we're good. Okay, so we are in the implied contract exception rule state. Okay. Now, covenant of good faith. Terminating employment when there's a covenant agreement of good faith is also grounds for wrongful termination suit. This is similar to implied contract exception, but it goes even further. A covenant of good faith between an employee and an employer exists when an employee performs his job's duties properly, and in spite of the performance, the employer terminates his employment. The termination is usually sneaky, underhanded, or selfish and in violation of good faith relationship between the employee and employer. I think I've been a victim of that because I've always done my job what I was supposed to do and they fired me anyway. They find some reason to fire me which wasn't true. And one thing that got to me about it in terms of unemployment, when an employer tells unemployment that you did something wrong, unemployment uses that as law. They say, well, your employer said you did this and you did that, so on the basis of what your employer said, we are not going to give you unemployment. You are denied unemployment, and therefore you're going to have to, work a certain amount of weeks in order to break the disqualification. You know, and I think that there's a lawsuit you could probably sue in that case too because the employer has lied. And it specifically says here, covenant of good faith. You know, first of all, you fired me because you wanted to fire me. I didn't do anything wrong, but you made up a whole bunch of things that you said that I did wrong, which I did not. And then you're going to stop me from getting unemployment by lying to them. So as you can see, yes, there's a lawsuit right there. And both you and I are going to have a lawsuit, baby. We're all going to be filing lawsuits in court against these employers. These employers are going to be walking on eggshells. They're going to be like, oh, you know, they're going to be very, very careful about who they hire. Because they're going to know that if they hire you, if they hire me, you better make darn sure that I'm the person that you want for that job. Because anything that you do or say to me, when you terminate me, could result in a lawsuit. And if you've already been slammed in court by $1 million or $100,000, you better watch out, baby, because y'all going to be out of business soon, okay? Come on, somebody talk to me. Okay, a covenant of good faith between an employee and an employer exists. Okay, I said that, right? Okay. All right. Now, an excellent example of breach of covenant of good faith is an employee who has worked for the company for many years and is about to retire with full benefits. I think that's what happened with this guy who got the 3.5. A few days before he is to retire, the company fires him. When you get fired, then you don't get the benefits that you were entitled to. If you get laid off, if the company downsizes you, you do not get those benefits. Okay, the underlying and underhanded reason is so the company won't have to pay his full retirement benefits. This is clearly a breach or a violation of the covenant of good faith. Okay, 11 states have accepted the covenant of good faith doctrine. The rest have not. Those with good faith covenant exception are those with the good faith exception are Alabama, Alaska, Arizona, California, Delaware, Idaho, Massachusetts, Montana, Nevada, Utah, and Wyoming. So we're out of that one. Now, number 4, written contract of employment. An exception normally applies to executives and upper management. When an employer offers a job to a prospect based on a written contract, the employer and the employee must abide by the employment contract's terms. Only when an employer fires an employee in violation of the written terms does the discharged employee have a valid wrongful termination case. The exception applies to all 50 states, so we good, baby. Number 5, constructive discharge. The exception occurs when an employee purposely alters a specific employee's working conditions and work environment to make it intolerable by any reasonable employee standard. As a result, the targeted employee has no choice but to resign. Although the employer doesn't expressly terminate the employee's job, the employee's resignation under the intolerable condition is a wrongful discharge. Check that out. Opening the employer up to a lawsuit, getting paid, baby. This exception won't apply if the employee knew of the working conditions before beginning employment and then later complains about the working conditions or work environment. And I think that would also apply to these warehouse jobs that are, you get these warehouse jobs and whatnot, and you get the job, and then you happen to look around and you see asbestos hanging on the wall. How long are you going to breathe that in? You know what I'm saying? Okay, you resign from that job, okay, because you're not going to work around that. That's a possibility you could sue. Now, as I mentioned to you before about the Equal Employment Opportunity Commission, okay, if you believe your employer wrongfully discharged you from your employment, the lawsuit against your former employee is considered to be a breach of contract, whether written or implied. Okay. Charging this phone up. Okay, whether written or implied. Okay. Alrighty. Okay. Whether written or implied. Now, if your discharge was due to discrimination based on race, color, creed, age, gender, or sexual preference, you may have 2 options. You must first proceed under the normal written complaint to the EEOC, and then proceed by filing a separate lawsuit against the employee for breach of contract. Ooh. Okay. Then you must file a separate lawsuit. Okay. Proving a wrongful termination case. If you're convinced your employee wrongfully fired you, you have to prove how and why. That requires evidence, and here's where to begin. Ask your employer to explain why he discharged you. Take notes if you can. Okay, some phones have a recording device on it that you can put. I don't know if they would allow you to use that as evidence, but ask the employer to put it in writing the reasons he terminated your employment. Okay, if you live in any but the following states, you can also secretly record the conversation. between you and your employee. You must make absolutely certain the recording is only between you and your employer and no other person, otherwise you've broken the law. The 12 states that prohibit recording a conversation do not include New York. Hey, they are California, Connecticut, Delaware, Florida, Illinois, Maryland, Massachusetts, Michigan, Montana, New Hampshire, Pennsylvania, and Washington, baby. We are good. Okay, so that means that you can secretly record the conversation between you and your employer and no one else. Ask to see your personnel file. Ask for copies of all document notes and other information contained in it. I've asked for copies of my file and I still haven't gotten a response. They don't answer the phone anymore and their email keeps getting rejected, but we're going to see about that. Okay, and other information contained in it. While most employers don't legally have to give you copies, it's always good to try. Okay, so I tried, so they don't have to give it to me. If necessary, your lawyer can subpoena them later after you file a lawsuit. See, now you can subpoena them. Subpoena them means that you're forcing them to give them up. And they have to comply with the subpoena, otherwise they're in violation of the law. And then other legal ramifications can be enacted. Create a journal for yourself. Write down the names and contact information of people involved in your termination. Include statements that they made prior to your discharge regarding positive commendations for work you performed well, if any. Also include references to other employees who your employee didn't fire even though their job performances were similar to yours. This may determine whether there was a double standard in place. In addition, write down the names and contact information of fellow employees who might later serve as witnesses on your behalf. Determine if your employer terminated you on an illegal discriminatory ground. If so, file an EEOC complaint and make copies of your application and any correspondence from the EEOC. Make sure you copy the right to sue letter you received from the EEOC. The right to sue letter permits you to file a federal lawsuit based on discrimination and entitles you to go ahead with a separate state breach of contract case. Be diligent because you only have 90 days after receipt of the right to sue letter to file the federal discrimination suit. You have much longer to file the breach of contract case. Check the statute or limitations for breach of contract in your state. Review the exceptions to the at-will employment policies. Each state will have slightly different policies. Okay, so determine whether your termination falls under one or more of the exceptions. If your company has an employee handbook, study the guidelines related to employee termination. Make copies of the pages dealing with employment termination policies. Is there an appeals process? If so, did employee deny you access to it? Did your employer fire you because you filed a workers' compensation case? Did your employer discharge you because you wouldn't break a law, cheat, or otherwise commit unethical behavior? Begin searching for another job if you feel so inclined, because 9 times out of 10, if they fired you for false, under false pretenses that you have the ability to sue, then more than likely they can disqualify you from getting unemployment, which is illegal. And I think that the unemployment should have a better standard of that because, we work for our money every year. That's why we pay insurance out of our paycheck for the unemployment. So if we get unemployed, we should be able to collect. Okay, but employees will badmouth us and say all manner of evil against us, which is not true, and then the unemployment office will use that as law. So I'm sure that there's probably a lawsuit for that, but I haven't seen that. Collecting unemployment, and we're going to contact the labor law, the New York State Department of Labor for that. Okay, begin searching for another job. Although the law doesn't require you to seek other employment before filing a breach of contract suit, wrongful termination suit, the EEOC claim, or the EEOC claim, it's very important to mitigate and lessen your damages. In other words, it won't impress a jury if you're complaining about lost wages and blaming the loss on your former employee if you haven't even tried to find a job. The role of attorneys. Although you can file an EEOC complaint, okay, and litigate it without legal representation, it's always a good idea to hire an attorney. Because the EEOC is known for hesitating to accept discrimination and wrongful termination cases without a history of a pattern of discrimination, you need to do a good deal of investigating. This is all but impossible without an attorney. EEOC cases and separate breach of contract wrongful discharge cases normally require a review of your employer's records. If your employer is a chain or major corporation, your attorney will need to subpoena access to the corporation's national records. Whether your employee is a small company or a large multinational one, you should know that you will fight hard for an employer to admit to wrongful termination, subjects them to thousands of dollars in damages. Furthermore, if you can show the termination was deliberate, malicious, or discriminatory, the employer will also be subject to a jury award of punitive damages. Punitive damages can reach into the hundreds of thousands of dollars. Also, if an employer admits to wrongful termination of an employee, that opens the door to others who were recently terminated to file a suit also, hoping to cash in on other cases, whether legitimate or not. Attorneys can take court-ordered depositions, recorded sworn statements of employers, present and past employees, witnesses, and more. Okay, they can subpoena copies of intra-company emails, memoranda, letters. In addition, your attorney can subpoena surveillance footage of the work area and discover complicity between and among your employer and others. Whether employees, corporate heads, vendors, and others who may know of the circumstances surrounding your case. Most importantly, your attorney can file a breach of contract, wrongful discharge lawsuit, and if necessary, proceed with the federal EEOC suit as well. If you are serious and determined to pursue your wrongful discharge case, you must have an experienced attorney. Often the mere filing of a lawsuit is enough to force a settlement. This probably won't happen if you try to handle the case yourself. Possibly, don't quote me on that. Just as important in the issue of legal fees, because EEOC violations and state breach of contract termination are forms of personal injury cases. Attorneys can expect them on a contingency-free basis. This means that you won't have to pay an attorney fee until or unless your case wins at trial or settles out of court. With all of that said and done, until you win that $1 million lawsuit, don't forget to hook a sister up. You need to begin updating your resume and preparing yourself for your next job. Though you may not have to work another day in your life, it's just a formality. Don't say you heard that from me. I contacted 2 of the organizations listed here, and I'm about to write the others. Like I said before, I'm going to contact all of them. And I think that I have, now that I've studied this update, I may found that I may have some lawsuits against some former employees that denied me unemployment because they lied on me and said that I did certain acts which I did not do. So now that you've gotten that out of the way, now that you've decided that you're going to file a lawsuit for your previous employer for wrongful termination, and you've gotten a lawyer, or you're looking for a lawyer, or you've contacted the national, federal, state governing agencies, and now you're ready to file a lawsuit, but you haven't found a lawyer, go ahead and proceed anyway. A lawyer might step up and say, hey, I see that you have a lawsuit filed, and then he may say, I'm representing so-and-so in this case, And once you've got these national organizations that help you, the federal agency, the state agency, and whatnot, then it's more than likely you may even have lawyers calling you up and saying, hey, look, I would like to know if you can help me handle this case. If I can help you handle this case so we can sue. You may get, you may have to just call around. But once you say that I have, that they decided that they're going to handle the complaint for me. See, the lawyer has a lot of work ahead of them, If you have time to do it, you're fired now. You got 6-month vacation coming to you. 6-month paid vacation. If you feel you got the time to do that, you can do it. You can subpoena the records just like the lawyer can subpoena the records. Subpoena the inter-office information, subpoena emails, subpoena the intranet documents. We had a thing called Jabber, which was an email only through the employees throughout that department. I think the whole company was able to access that Jabber system. So you put something in there, and that stays in the system for a number of years. So that's accessible. That could be subpoenaed. The emails can also be subpoenaed. Video footage can be subpoenaed in terms of what actually went down. That classroom that I was in, when I was taking the classroom lessons, that can be subpoenaed, and you can determine when that woman actually hit me. You know what I mean? A whole lot of stuff can take place, baby. Oh yeah, we all got a lawsuit. If you need help, like I said, contact these agencies, write them a letter. Get a copy of this book, you know what I mean? And this will help you, guide you in the right direction and give you the information that you need so that you can proceed with caution. Okay, it's called You're Fired, Handling the Exit Interview with Grace. You know, when I walk out of there, I'll be like, well, thank you for firing me because you just, gave me a lawsuit. Now I'm going to have an early retirement thanks to you. Thank you. So when you walk out like a standing ovation, like everybody standing, looking at you like you crazy, like, why is she thanking me? Because I'm about to get paid. You wrongfully terminated me. Thank you. And now I'm going to sue you. Thank you. I'm going to file a claim. I'm going to file a case against you for every legitimate agency that I can think of. And when I go to court, I'm going to file a lawsuit against you for $100,000 or maybe even $1 million. Okay? You can get the best lawyer. A lot of times they will work on contingency if they know they have a case. But if you just call them up without contacting these agencies, there's a possibility that they said that oh, I'm sorry, but we can't handle that. Because, they want the big bucks. You know what I mean? But I don't want to hire somebody who's not going to be on my side. You're a lawyer, okay? If I call you up, you're supposed to be compassionate about my situation. I told you I was wrongfully terminated. And then as soon as I tell you one little thing, you're going to tell me, oh, well, they don't have to, blah, blah, blah. They don't have to do this. You're defending them, and I'm calling you for assistance and help. That's a definite sign right there. Hang up the phone and leave them alone. And a lot of times these lawyers, they got the nerve to want I got to pay you $300? I got to pay you $300 just to come and talk to you? Wow, I'm going to start doing that. That's a whole business right then and there. I'm a real estate broker. You charge you $100 just to come and sit and talk to me and see what I have available. You know what I mean? Wow, I can make money just from sitting there talking to you. But anyway, I want to thank you for joining me today for Real Estate, Religion, and You. This has been fun. I've learned a lot. You've learned a lot, I'm sure, I hope. Anyway, it's not too late to start updating your resume. You know what I mean? Definitely update your resume because you want another job, at least for the time being. You know what I mean? So that your mind, so you're not thinking about that $1 million that you're going to get. Because it's a long, hard journey, baby, and it's hard work. It could take a year or less. You know what I mean? It could take a couple of months. Who knows? But maybe it's time for you to settle and look for a different kind of job. You know what I mean? When you are ready. Okay, don't just force yourself to go out there and start looking for work if you're not ready. Because prepare yourself for interviews. When you're ready, get your mind, in order first before you do all of this. Because a lot of times your mind ain't ready to handle it. You can go sit before an employer, and just, be all mad and whatnot and got your face all screw face, and they can tell. And you don't want that. You want to be, be able to get the job, And the first thing somebody say to you, you be like, what'd you say to me? Bam, you know what I mean? Knock them in the head. So, when you're ready to look for work, don't do it until you're ready. You know what I mean? And if let a month go by, sometimes you need a whole month just to chill out and relax and get your head together. You know what I mean? Rather than going out there going to look for another job right away because your mind ain't right. But first to see if there's a way that you can get somebody on your side to help you with this mess. And then maybe that'll put you in a better state of mind to go get a job. Or at least look for a job anyway and to conduct a successful interview. Try to memorize your resume and all of that. Okay, so this will conclude the You're Fired session. Talked about You're Fired, handling the exit interview with Grace. And this is available on lulu.com. If you want an ebook, I'd be glad to give that to you. That's only available through me at sblack3001@gmail.com. You can also view my YouTube address at sblack3001. And please join me next week right here on Time Warner Public Access TV Channel 20, Wednesdays 6:30 to 7 and Saturdays from 12:30 to 1 in the afternoon. For Real Estate, Religion, and You. And my name is Dr. Sylvia Black, and I'm your host. Holla at a sister. Holla at a sister, y'all. Only when you're ready. Don't do it until you're ready. Holla at a sister.